Thank you.
Thank you, Acting President. I too rise to speak on the Sale of Land Amendment Bill 2019. This bill is tough on dodgy developers and will offer protection for buyers. The Sale of Land Act 1962, which was enacted in 1962, was for the purpose of protecting purchasers under terms contracts and contracts for the sale of land off the plan. After that, the Act was amended to protect the interest of property purchasers more generally, and it regulates certain aspects of real estate. It regulates the treatment of deposit monies, provides for mandatory pre-contractual vendor disclosures, and regulate public auctions, among other things. It is recognized as a critical piece of consumer protection legislation which underpins Victorian property law. During 2016 and 2017, the Act's operation was examined as part of the Andrews Labour government, where we did the broader review of the consumer property law. This bill continues to support the Act's role in providing critical consumer protection by introducing a number of key reforms to address the important consumer drawbacks which are in the Victorian property market. These drawbacks were identified during the review of the Act. There are a few key reforms which will be part of the Sale of Land Amendment Bill. One of the key reforms this bill brings relates to the use of sunset clauses. The sunset clauses are the off-the-plan contracts that commonly include provisions giving the developer or the vendor the right to end the contract if a plan of subdivision for the development has not been registered by a specific date. During the review and also since last 18 months, many of my fellow MPs have received increasing number of correspondence from Victorians who have bought property of the plan and whose contracts appear likely to be terminated by developers under the sunset clauses. These Victorians who have bought the properties are hardworking people who have worked all their life to save money for the deposit, to build a home, but the dodgy developers, they do not care. In some cases, buyers' contracts have been terminated only for the developer to subsequently register the plan of subdivision and offer the property for sale at a higher price. It's just about profits, not worrying about people, their homes, their livelihood. In other cases, the dodgy developers have also threatened to use the sunset clauses to terminate the signed contracts unless the buyers pay additional sum. This is outright bullying. And now, we might think that why don't these buyers take legal action against these vendors or developers? Taking such actions against these big developers or vendors is beyond the means of most Victorians. And although the number of developers who may seek to take advantage of the ending of the rights is generally low, the risk of this occurring increases when the price of the property increases faster than expected. Termination under a sunset clause in an attempt to capture this value, the profit is therefore entirely opportunistic. Despite having paid a significant deposit amount and having waited a long period of time to have the property, upon ending the contract, the purchasers are denied of the benefits of any increases in the value of the property, and once they get repaid the money from the vendors or the developers, they get only their deposit back, and that too without the interest. And then what happens is, then they have to go and look for a property. Once they start looking, of course, the property prices would have significantly increased then, so then it becomes difficult for them to buy the property. So this opportunistic behavior on the developer's part is costing Victorian money and causes a lot of unnecessary stress. And this behavior actually leads to the loss of confidence in the integrity of the plan industry. So these amendments are significant. Normally, the state does not interfere in private contractual arrangements, and generally a purchaser wishing to challenge the vendor who is benefiting from this on a basis of the contractual term, the purchaser would have agreed, would be required to take legal action. However, the extent of consumer detriment caused by the developer misuse of the sunset clauses and its impact on Victorians' confidence in the off-the-plan market warrants a legislative solution. And therefore, in order to address the misuse of sunset clauses by vendors, the bill provides a vendor that they may not end a residential off-the-plan contract under the sunset clause without the agreement of the purchaser, or alternatively the express permission of the Supreme Court, or else it will constitute a breach of contract which will enable the affected purchaser to claim damages or appropriate remedies from the vendor. The bill also provides, under this bill, the provisions are that it would have taken to come into operation on 23rd of August, the day after the day on which the sale of Land Amendment Bill 2018 was second read. For the dodgy developers, the existing off-the-plan contracts before this bill passes, they just want to end it, because that way then it will be an attempt for them to ensure that they are not subject to the sunset clause reform which will happen through this bill. But Andrew's Labour government has made in this legislation, has made clear that a vendor's ending of a contract under a sunset clause after the date on which this bill was initially second read in the Parliament will be ineffective unless it occurred with the purchaser's consent. Purchasers also have a contractual right to terminate a plan if it has not been registered by a certain date and in the absence of a contractual right. The second important reform which is part of this bill is to prohibit certain terms contracts and rent-to-buy arrangements. So this bill also introduces the prohibition on selling residential land under a rent-to-buy arrangement with certain exceptions. The predatory conduct in the alternative housing finance sector has led to vulnerable consumers entering into unaffordable and high-risk terms contracts or rent-to-buy arrangements for the purchase of residential property. Term contracts and rent-to-buy arrangements are often sold by finance brokers as the financial solution to people who are unable to access the credit from the mainstream credit market. But these are the people who are very desperate to enter the property market. They want to buy their own residential properties. So previously, what used to happen is that the market for these sort of deals, the terms contracts and the rent-to-buy arrangement, used to be in lower value housing in regional or remote areas, but that is shifting. We are seeing these sort of deals also in lower value housing in the outer metropolitan area now, and it's also happening in my electorate of Western Metropolitan Region. Now, rent-to-buy arrangements are presenting significant risk to the buyers. For example, if during the rental period, if the tenants are not able to pay a rent for a month, then the landlord can potentially terminate the contract, and this will lead to the termination of the lease as well as the end of the termination of the rent-to-buy arrangement. And upon the termination of the lease, the person will lose both their option to purchase and also any fees that they would have paid under the sale option. During the review of the Land Act, they did not see many benefits of the rent-to-buy arrangements. And in fact, there was a substantial feedback that there are not many benefits of such arrangement. The only winners in these transactions are tend to be the finance brokers who do these deals. However, the government recognizes that future models of rent-to-buy arrangements may be legitimate and that this should not be prevented. The third reform that is part of the bill is discouraging the unregulated and land banking schemes. The bill also closes a regulatory gap that has enabled developers associated with unregulated and problematic land banking schemes to unsophisticated investors without regard to their interest. Before any formal subdivision or development has occurred, small-scale domestic investors are offered the opportunity to either buy a lot of the plan or pay money to purchase an option to buy a lot at some point of time in the future. And the value of the option is tied to the likelihood of the land being approved for the development by the relevant council, and that's where the purchaser will make a profit once the council has given the permit. While monies paid by purchasers are protected under the Act, the purchase of an option to buy land are not covered under this. And as a result, what happens is there are chances that it may be unsuitable for development or rezoning, and the money that gets paid for this option, it doesn't get in the trust account, and therefore there is a risk of the loss of the money. Previous land banking schemes have involved the sale of options which have collapsed and where the purchasers have lost the money. These properties brokers who sell such options, they exploit unwary investors through their dubious banking schemes. The other fourth point of this bill is the strengthening of pre-sale disclosure. The bill also includes amendments to include some of the issues. While they are not we don't see it frequently, but they are of concern to the community when they arise. And one such issue is the disclosure of the certain facts, the material facts when they are selling the property. The example could be, it could be a site of a history of the site of the homicide, or the past use of the property could be the manufacturing of the illicit drug. And so it is currently an offense under Section 12 of the Sale of Land Act for any person with the intention of inducing another person to buy land to fraudulently conceal misleading facts. And this bill is going to replace the word fraudulently with knowingly. And they will also provide for legislative guidelines to be prepared by the Director of the Consumer Affairs of Victoria, which will clarify what a material fact will be. And these reforms will encourage the estate agents to do their due diligence before they list the property for sale, and also complement existing laws whereby they are liable for recklessly making a statement which is misleading. And the last point of reform for this bill is public auctions on Anzac Day. The Andrews Labour government had listened to the concerns raised by some people that the public auction should not be conducted on the day when it's Anzac Day before 1 p.m. And in recognition of the community concern about public auctions being conducted, the bill will amend the Anzac Day Act 1958 to prohibit public auctions being conducted before 1 p.m. on Anzac Day. This doesn't happen frequently. However, sometimes Anzac Day does fall on Saturday, where most of the auctions are being conducted, and sometimes on Sunday as well. In 2015, Anzac Day fell on a Saturday, and 18 auctions were conducted on that day before 1 p.m. In conclusion, I would like to take this opportunity to thank the stakeholders who have participated in the review of this Act. The bill introduces critical reforms which are designed to mitigate the consumer detriment identified during the review, while allowing legitimate and beneficial property transactions. Therefore, I commend the bill to the House.